Thank you indeed, and thank you for kind introductory words as well. I wish to start with thanking Maria Filomena Gonzalez for invitation to come and to contribute to this Congress. And I also wish to congratulate the University of Évora for hosting already for a decade UNESCO chair in the field of intangible cultural heritage, which is quite a significant time period if we think that it's already kind of half of the life of the convention. So I think it has been quite an early decision to establish a UNESCO chair here. As it was already said, UNESCO chair that I represent is 4 years younger. What we might eventually call as a little sister of the chair that you have here, and it focuses indeed on cultural, intangible cultural heritage policies and laws in various countries, as far as we study that through different research projects. We have been discussing over these 2 years various aspects very intensely and in very rich manner, aspects which are related to UNESCO 2003 convention, in a way commemorating or celebrating 20 years since its adoption. And in this regard, I would like to dwell, so to say, on the notion of time in my upcoming speech. So we'll try to relate to some of the aspects that have been raised over these 2 days during the presentations. And I will also share some, to some extent, personal connections to various elements of intangible cultural heritage, met, if I may say so, through the processes of inventorying and listing, so both at the national and international level. So I will share some pictures, all of which are coming from intangible cultural heritage nominations, so pictures which have been deliberately also made for the purpose either to make the element visible on the inventory or further on the national list. The first picture, which probably some of you recognize, it comes from Portugal. It has been a nomination of manufacture of cowbells, which was inscribed in 2015 on the urgent safeguarding list. And of course, it is an example brought up being here in Portugal at this occasion, but it is also an example that I bear close to some extent, and I kind of raise it time after time. I do believe that this has been a nomination which in a way proves that within all the machinery around nominating elements, where you do have concrete questions to answer, you do have quite a set format how to do that. You have vocabulary to use or not to use, as we learned at the early on in the conference. Even with all this scenery set, you can still have your own writing in the way how you present the story. And I think this particular nomination has been very strong and very concise, how you tell the story to some extent, even in a very, if I may say so, poetic manner. When we go through the text and we go through the pictures and we see the video, it all gives a little bit kind of a feeling of a literary and creative work behind really making the story about cowbell making. But then the other reason for choosing this example is also that, for instance, this particular picture as well, it in a way captures the idea of time which needs to be spent on certain practices we do. Either this is cowbell making in this particular case, but it can also be work on the convention's text, for instance, where, as we also heard early in the Congress, where people are involved, scholars, professionals, and they do also pass their time in thinking how we will word one or the other phenomenon, or how we will build the consensus around what we wish to decide. And consensus building is specifically that I will use a little bit as a driving element through my talk, trying to see what aspects during the life of the convention, and even before, what aspects have been consensual, where we really have reached a certain agreement and we move on with certain decisions taken, including convention's text. But then also in addition to that, there have been non-consensual issues which have been left beyond the convention. And we see that to some extent, if the consensual side of things have allowed us to move on quite rapidly with different policy development, it has been quite an intense period altogether, these 20 years since the adoption of the convention. But then these non-consensual issues, they are in a different temporality, if I can say so, because they do demand a certain slow, ongoing discussions, which are still, at this present moment as well, continuing. And I will come to concrete issues which are still on the table as non-consensual around intangible cultural heritage. But then regarding the time and the reflection about time, it is not only regarding non-consensual questions that slow advancement is needed, but to some extent we also hear an appeal or voices or interest in slow advancement also from community side. So that we sometimes also need to respect those calls for a different time of advancement than our intentions eventually to go rapidly with developing different policies and laws. So I will dwell on these questions about time and consensus building. And I will try to concentrate on two aspects. One is, again, very much discussed, I have to agree so, but still the question about terminologies and conceptual influence of the 2003 convention. And the other one is an open question, so what does it bring or not in legal terms, whether we do or not create some additional rights, obligations, and so on, and how do we see both of these aspects, like conceptual one, but then also kind of legal instrumental one at international and then also national level. And I will start by the international level in this regard. And then comes yet another picture. We saw this picture earlier today in the presentation, which where legal aspects were also addressed. And this is a picture, again, coming from a nomination, this time from Brazil, also proposed for the urgent safeguarding list and inscribed back in 2011, which is quite early in the operational kind of work of the urgent safeguarding list in particular. And what we see here, so the nomination, the title of the nomination is Yaokwa, the Enawenanawe People's Ritual for the Maintenance of Social and Cosmic Order. And why this picture is chosen? I do refer now back to, indeed, a personal experience being part of the kind of decision-making setting at the Intergovernmental Committee. And we discussed also these kind of, what does it mean? We discussed this earlier in the conference. And I wish to cite an extract of the periodic report that was examined back in 2013. So it was a periodic report about how things are going with this nomination. So it was 2 years after the nomination was inscribed. So what could we read in this report, which was submitted by Brazil for the examination at the Intergovernmental Committee? And now I cite, to reach the indigenous lands, it is necessary to fly an hour and a half from Ciuaba, the capital of Mato Grosso, to the city of Juína, and my apologies for pronunciation, in the interior of the state, From there, it is an hour by car to the mooring point of the river, with a further 8 hours by boat to the village of the Enawenanawe. Even today, there's almost no contact between this ethnic group and society surrounding their territories, a fact that makes their participation in the planning and implementing of safeguarding actions difficult. However, it is worth noting that the Enawenanawe leaders make weekly telephone contact with the local office of IFAN, which is Institute for Historical Artistic Heritage in Brazil, in Mato Grosso state. And despite their poor Portuguese, an exchange of information takes place regarding the actions carried out by both parties, so by state and by the community. So that was part of the periodic report that we could read back in 2013, a decade ago, which was brought to the attention of the Intergovernmental Committee. And then those present there, part of delegations, need to take certain decisions in this regard. And that was the moment when personally I felt quite a strong distance between intergovernmental discussions where governmental representatives are involved, and then indeed subject matter or people we are talking about. And these geographical distances, which are described here in the report, they also become or put delegations in quite an uneasy situation so how can we really discuss that without people being somehow involved in our discussion? But nonetheless, coming to the institutional, intergovernmental and international level, and regarding these conceptual aspects and consensual aspects that I was mentioning. So intangible cultural heritage, as we all know, has been indeed a novel concept proposed internationally through the text of 2003 Convention, although similar concepts have been existing in other countries, some countries previously. And the concept is uneasy also from a legal point of view, because we strongly speak about people and what people do, about certain actions, about people's lives, and really the way people act. And on the other hand, there is this a little bit kind of hint of thought of property, without putting that in concrete words, but still having the whole also legislative experience internationally behind about cultural property protection, and also the 2003 Convention finally very much relying on the World Heritage Convention's text, even the way how the 2003 Convention was drafted. So there was these, in a way, quite opposite references, a person and a property, so how to put all of this together in a novel legal concept. So, but anyhow, so intangible cultural heritage as a concept was coined, and as I mentioned, it has had and it continues to have, to my mind, quite a strong conceptual impact. And just to give some examples, at the global international level, we heard earlier also during the Congress that, for instance, human right, which is namely right to take part in cultural life, has been, let's say, part of human rights early on already from United Nations Human Rights Declaration of 1948. So that has been already for a long time. But what has changed is that with the adoption of the convention, very clearly and much more, we also emphasize that this human right includes also rights to intangible cultural heritage, for instance. We see, for instance, in documents which are at the United Nations level addressing cultural rights and also addressing indigenous people's rights, that intangible cultural heritage as a concept is very much present, but that is quite a recent tendency. So, for instance, in the work of the United Nations Special Rapporteur in the field of cultural rights, There are intangible cultural heritage issues addressed in these reports. The same goes for the United Nations Special Rapporteur in the field of indigenous rights. And again, intangible cultural heritage is very much present there. It doesn't mean that none of these aspects would have been raised or deliberately kind of taken care of before the convention was adopted, but now with this new concept being introduced, all these different separate aspects and elements, they are brought really together under one single concept, and that becomes much more stronger in order to advocate that intangible cultural heritage is something that we would need to take care of. And this happens, as we see, beyond the way as convention itself operates in UNESCO. We see similar tendencies also at the regional level in Europe. And again, that was already mentioned today, where references were given to Council of Europe, to European Union documents, and we saw reference also to Faro Convention earlier on in this Congress. And if we take a look at this Faro Convention or in full title, Council of Europe Framework Convention on the Value of Cultural Heritage for Society, then we do read there that parties to this convention agree to recognize that rights relating to cultural heritage are inherent in the right to participate in cultural life. So it has been very clearly stated that indeed heritage matters are part of this particular human right. And we see, as for the European Union, then indeed very clearly putting kind of side by side tangible and intangible cultural heritage is, in a way, constantly an attitude which is visible not only in policy documents which directly address culture, as, for instance, the document that was referenced earlier today about the integrated approach to cultural heritage. But we see similar kind of consistency also in other policies. For instance, now we discuss more and more the connection between heritage and climate change. So if we do take a look at the climate change policy documents where they address different mitigation strategies or how we should go about it, we also do see references to both tangible as well as intangible heritage. We have to say, though, that in the national policies which do address climate change within the European region, states are not that keen yet, probably, to directly, explicitly say that this is also something that intangible cultural heritage is concerned with. But at the European level, we see that reference very clearly. And then also, finally, regarding this international level, which is not less important, we have been seeing a whole novel kind of disciplinary shift in scholarly research. So there have been new kind of research fields opening after the convention. There have been a lot of discussions about the convention itself and what does it bring and what sort of impact it is having or might have possibly in the future. So this new legal instrument has meant quite a lot also for the scholarly development. But then coming to the other side of things, besides conceptual, coming to kind of this legal operational side of things, and that was also said earlier in the Congress, that in the end, 2003 Convention is quite a soft legal instrument, so that there are, of course, principles stated, and that is important. There are also some state obligations stated, including establishing inventories, including developing possibly other safeguarding measures, including also reporting on what is happening within the state's territories. But we do not see any clear rights that would be stated, for instance, for communities, groups, and individuals. So that really remains very much also the responsibility to governments and national level, so how the convention is really put into practice and whether it comes along with clearly stating or defining certain rights. But however, even if we do see this kind of soft side of the convention, there's a lot happening because of the convention or having it as an instrument. And here I would wish really to refer to the inventorying, which has been, we had a whole panel around inventorying in this Congress, and we see to what extent it is an instrument of power, as it was said, but then also an instrument for communities to use for their own sake, be it for the visibility or for other reasons. So a lot is happening for inventorying within countries, but then also at international level through listing. We heard also about the importance of international cooperation, and again, convention provides opportunity to have novel cooperations through, be that listing mechanisms including, for instance, through multinational nominations, but also beyond that. So this is, in a way, we might say that having a look at this convention, building inventories and building lists has been this consensual part, so that is something that we could agree upon. However, if we look back at the discussions before the convention was adopted, it's not that every country would have the same opinion about that. There were also opinions expressed, for instance, from Nordic countries saying that lists might, in a way, create some sort of competition between communities, between states, and that is something that we probably do not wish. But there was really a clear consensus around the interest in having inventories at the national level. So that was not that much contested or discussed. But anyhow, these both inventorying and listing was adopted in the convention as modalities how it could work. And here I come to the national level, or what is happening within countries, and yet another picture, which is taken from a nomination which was inscribed or inventoried, we might say, which is on the Latvian National Inventory of Intangible Cultural Heritage, and it concerns Livonian cultural space. And I've chosen that for several reasons, but before I say that, just to give a little bit of context, so Livonians are recognized in Latvia by the state as indigenous people in Latvia. And there are several kind of eventually reasons for that. There have been different terminology used before. It has been a lot of advocacy from Livonians themselves to use this international terminology also for their own sake. But in any case, historically, there have been both like predecessors of Livonians and Latvians living in different regions in the territory of Latvia, present-day Latvia, and we have historical records about inhabitants in the Latvian territory dating back from 9th to 13th century, and then records about Livonians being there starting from 11th century. But anyhow, so there have been like coexistence of both, which is a bit eventually a different kind of situation comparing to other countries where the notion of indigenous people is used. But anyway, choosing this particular case, so I mentioned advocacy. So having the 2003 convention, let's say, behind, and having also using the reference to the United Nations Declaration on the Rights of Indigenous Peoples, those have been references for this particular community to advocate for their status, to advocate also for much clearer formulations regarding their linguistic rights and having much clearer policies in supporting Livonian community. And when I say Livonian community, it is only a matter of about 250 people who identify themselves as Livonians. So it's really tiny community who's striving to survive culturally to maintain their cultural identity. In that sense, they have succeeded to some extent, but then also I've chosen this example as this is one of the several elements on the Latvian inventory where the notion cultural space is used. That was a notion much more used in the UNESCO context before the 2003 convention. And if we take a look at the international list, we see how this concept has been fading away. There have been initially quite a number of nominations using this opportunity, but then nominations are becoming much more specific in what you nominate, which is probably also a matter that is eventually easier to tell about comparing to a whole cultural space. But cultural spaces in Latvia, and that is a kind of side effect of the policy on intangible cultural heritage, that there was a separate law adopted on historical Latvian lands or regions, we might say, where there is a policy support to different initiatives to preserve local cultural identities. And there, the term cultural space is used in this other legislative act. And we see a concrete connection to the recognition of cultural spaces on the inventory, and then support which is given through another instrument, let's say regional cultural policy instrument, which was not at all initially thought like this. So it's kind of a side consequence, and which in a way illustrates that despite firstly seeing eventually kind of limited outreach of the 2003 convention, there might be consequences that we don't really predict initially, but that can lead to certain support to communities through other ways. But talking more broadly about the conceptual impact of the 2003 convention on what is happening at the national level, so we see that countries are taking up this concept and using that in their own laws, in their own policy documents. In some countries, it has been before the convention, including Brazil, Japan, South Korea, Algeria. But then mostly this concept is really being used after the convention was adopted. And there are different approaches in legal terms. There have been laws specifically elaborated on intangible cultural heritage, to name, for instance, in China, Madagascar, but then also in Latvia and Thailand. And then there are cases, including France, which was named earlier in the Congress, where intangible cultural heritage is referenced as part of heritage, as a notion integrated, but in a broader context of cultural heritage law. So there are different approaches to that. But in any case, another issue we discussed during the Congress was about intangible cultural heritage domains, and there was a question asked earlier whether, for instance, gastronomic heritage would need to be added as this additional domain, let's say, in the convention. Although it would be quite a challenge, opening a whole legal procedure, unrealistic, I would say, to change the convention as such, knowing that countries 181 have adopted the convention's text as it is. But there are opportunities to vary these domains at the national level, and that is also what we see in different countries. That in fact, for instance, in Thailand, they have martial arts mentioned as part of the intangible cultural heritage as a separate domain. We do have also gastronomy and specific use of natural landscapes, which is mentioned in Spain as part of intangible heritage. Gastronomy is also mentioned in Peru as a domain, but then also referencing indigenous languages and traditional systems of local authorities, ethnomedicine, for instance, and ethnobotany. So all of these are also mentioned as part of the intangible heritage domains. In Kenya, for instance, they mention also cultural landscapes, and in Albania, language is mentioned as well. In other words, countries can and are really doing so, adopting the intangible cultural heritage concept to their own contexts and needs. And so we see, kind of variety around intangible heritage concept in different contexts. And then this other side, about the kind of legal operational manners. I was mentioning the Livonian case and the way how legislative developments in the end have led to certain creation of rights for this particular Livonian community, especially regarding the use of their language. And to some extent, sometimes it can be also so that existing rights are just really put into practice with the help of the 2003 convention, so that some rights which have been existing, including in regarding languages, for instance. They have been made stronger with the additional argument of the 2003 Convention. But regarding what is happening at national level and inventorying in particular, there's also another aspect that I wish to mention, and what we can see from periodic reports about different elements in different countries, reports that have been submitted to UNESCO for examination. We see more and more that a lot of effort is put into inventorying. So there's a lot of documentation ongoing. There's a lot of data collected. There's a lot of, in different forms, including digital archives being established and so on. But in these reports, there is quite a little attention paid to how these massive documentation is going to be administered, or how we will manage access to data, how we will protect data, how we will ensure that there is a long-term preservation of the material documented. So there's quite a little attention paid to that, and I think that is something that we will need to discuss much more in depth. That this is also a certain kind of legal side of things, also for inventorying, which need to be taken care of. And there's different processes which have been ongoing in countries. We have been trying to explore just some part of that through a research project that we had together with the French scholars, and that was under the title of Osmosis. And I'm thankful for colleagues also who are in the hall here and the Congress who have been contributing also to this particular research project. And we published that already a couple of years ago, trying to see what is happening with terminology that I was mentioning in different countries, but then also how different connections to other fields of law are being established, be that environmental law, or be that human rights law, or also intellectual property protection law. So those issues have been addressed more in depth in some of the publications. And earlier, also in the Congress, we heard references to Janet Blake and Lucas Lixingsy, who have been also very much involved in scholarly research about the convention. And I wished also to reference the commentary that was prepared, kind of commenting every single article of the 2003 convention. And yet again, we were a big group of people contributing. So there has been a lot to say, and there probably will be a lot to say still in the years to come. And then urgency was something that we discussed also earlier in the Congress. So to what extent we do have or not a clear idea what do we mean by urgent safeguarding. And this is a kind of an aspect apart or specific, but I felt important to mention. And the picture here is coming from yet another nomination, which is entitled Culture of Ukrainian Borscht Cooking, which is the first ever case of an inscription on the basis of extreme urgency, the only case this far. The nomination was prepared originally as a nomination for the representative list. So that was the initial idea, intention, and the nomination was written for the representative list. But then with the change of events that we are all very much aware of, there was a choice by Ukrainian states, together with communities involved, to change that, and in fact to propose that nomination to the urgent safeguarding list, and to ask for the nomination to be examined as a case of extreme urgency. So the nomination was slightly adjusted and adopted, because so the format is different for the urgent safeguarding list, but that was done in a quite a rapid manner, and then it was proposed, and it was inscribed last year on the urgent safeguarding list. And this year at the committee session, there will be the first report because the committee asked to have the first report in 1 year's period, which is also extraordinary. And the first report will be examined this year by the committee. And yet again, this case in a way shows, or on the one hand, that there are urgencies where we can raise intangible cultural heritage as something important internationally, but then also the way how the situation can or cannot be solved, those are other arenas where that is happening. So that 2003 Convention, of course, can go as far as it can in assisting, and there have been projects also in very concretely trying to help Ukrainian refugees in neighboring countries, and there has been UNESCO assistance for that provided. But still, it probably doesn't solve the urgency situation as such. But then also, regarding this case, there's another aspect of this international conceptual impact that I wanted to raise, in addition to what I was mentioning previously. If we take a look at, international courts operating, and here I think in particular about International Criminal Court, as that has been also discussed, is eventually regarding Ukraine, and there's a process ongoing at the International Criminal Court. If we take a look at a policy document that has been elaborated by the International Criminal Court's Office of Prosecutor, there was a policy document on cultural heritage, which was issued in June 2021. And in that document, very clearly again, it talks about, and it gives example of previous cases where crimes against humanity, war crimes, genocide crimes, that regarding all of this, it concerns not only, for instance, the destruction of cultural heritage sites, the tangible side of things, where we do have also a court case very clearly where criminal responsibility has been there because of the destruction of heritage sites in Mali, for instance. But then what this policy document emphasizes is that we need to take a close look also how, what different military situations and wars ongoing and so on, what does it mean for intangible cultural heritage? In other words, that there is criminal liability also regarding crimes that are there that affect intangible cultural heritage safeguarding. And that is, I think, an important reminder. We will see to what extent it also affects, for instance, gathering of evidence and so on regarding this particular case. But anyhow, it is yet another way how intangible cultural heritage has been emphasized. And again, it doesn't say that no attention to these issues have been there before the 2003 Convention, but having a single concept for that, it makes discussion about that very much more stronger. And a final picture that I have, and I would like to come to this this lowliness side of things, or aspects that have been non-consensual and that still demand some discussions. And here in particular, the picture that I have chosen, that comes from Intangible Cultural Heritage Inventory, which is in the form of wiki inventory in Finland. And it concerns Sami indigenous people, and in this particular case it concerns Sami handicrafts. But as we know, Sami indigenous people are spread across 4 countries, Norway, Sweden, and then also Finland, and also Russia. Why this particular choice, and how do that relates to the discussion around the convention more broadly? So there are 2 non-consensual aspects that I wanted to raise, where the discussions are still ongoing and where the discussions have been there already before the 2003 Convention. One of these aspects is the protection of intellectual property rights, and the other aspect is rights of indigenous peoples. These are not the only aspects that we might be discussing, but these are two I wish to propose today. Regarding intellectual property, it is interesting to see back what was the kind of the origin, to some extent, of the 2003 convention. The work of scholar Waldemar Hafstein was also referenced earlier today, and he has been very closely looking into a story behind the convention, which dates back to 1973, and a letter from Bolivia, which initiated a whole discussion. And I just wanted to cite some part of this particular letter. We can read there that cultural expressions as music and dance being threatened by intensive commercialization and export, transculturation, with no proper indication of the origin of concrete cultural expressions, an idea of an international register of folkloristic cultural property was something that was proposed by this letter from Bolivia. Later on, in 1982, where already a concrete instrument was discussed, which took form later as a recommendation, which was referenced early in the Congress, recommendation on the safeguarding of traditional culture and folklore. Before it was adopted, we read, for instance, a writing by Professor Lauri Honko, who was folklorist from Finland, and back then in 1980s, folklorists were quite influential in decision-making at UNESCO, and he was leading the expert group who were working on the recommendation of 1989. But back then, in 1982, he was writing, "It is necessary to consider ways in which the bearers and users of tradition can be defined and supervised so that the economic gains can be channeled back to the societies to which the traditions belong." And to some extent, I think there is even a sort of connection with the ethical principles that have been adopted, like 3 decades or more even later. But those were discussions early on, but the intellectual property issue altogether was left deliberately outside the 2003 convention because of this very much non-consensual aspect of it, characterized, for instance, by what is happening at the World Intellectual Property Organization, where no decision is really properly being reached on how traditional knowledge could be protected. There are intentions, also regionally, for instance, discussions ongoing between Finland, Norway, and Sweden, whether at the regional level there might be a convention adopted how to protect Sami traditional knowledge. But yet again, it is not a consensual matter yet, so it might still take time. And the same goes to discussions about the rights of indigenous peoples. And if we take a look at some of the writings of people involved, legal scholars who have been also part of the work on the 2003 Convention's text, then, for instance, Paul Kuruk, who has been one of the legal experts, has named the convention as a missed opportunity, so that it doesn't really give concrete instruments for indigenous peoples to defend their interests and rights in the cases of misappropriation and unauthorized use of their heritage. But then we also read, for instance, what Janet Blake writes, who has been also very much involved in writing the 2003 Convention and in the work afterwards, where she says that it has been a compromise position, the text of the 2003 Convention, so that to keep also those countries on board who are in general interested in intangible cultural heritage safeguarding, but who are not that keen in really putting very clearly what would be the solution to propose legally for indigenous peoples' rights issue, or for rights issue more broadly. Anyways, coming to concluding and yet thinking about time, and this was another reason why I chose to mention Sami. So I have been trying to observe discussions over the last years around Sami intangible cultural heritage safeguarding, what discussions have been ongoing in the Nordic countries, whether a common inventory could be established between the countries as a cross-border inventory. That is still being discussed. But anyhow, in these different contexts, different formats of debates, exchanges, and so on, there was an acknowledgement or a feeling or a statement which was repeatedly there from representatives of Sami communities. And that was, to put it shortly, that we need time. We need time to discuss. We need time to reflect. We need time to take a common decision that would suit all of us. For instance, in the case of Sami, that would suit Sami communities across the borders. And this reminder that we need time in a way kind of wakens and says that probably indeed there are different temporalities. There's the one of policy making where we probably wish to move on with certain periods, with certain reporting or other periods, with certain decision making on how inventories should be established, how the engagement, how active it should be. But there's also this other temporality of those who are really practicing their lifestyles and really willing to safeguard for their own sake, despite these other temporalities which are existing all around. And I think that was an important, in a way, reminder. So having said this, and taking back a look at those aspects that I tried to raise at this occasion, so there have been quite an intense changes, we might suppose, after the 2003 convention being adopted on this conceptual impact side, on the consensual side of things, where we have been agreeing about certain aspects, but there are also issues which have been deliberately left behind, but to which we are coming back. And we see that, for instance, intellectual property issues and also now indigenous peoples issues, they are now being more and more raised in documents which are accompanying the 2003 convention. So there's a conventions text which probably will stay as it is, but there's a whole set of documents which are being elaborated afterwards, and that is the way how we see the dynamics around the 2003 convention, where new content is put in these new documents. And to mention another one, in addition to the document that's already mentioned around good safeguarding practices, which will be discussed at the committee session this year, but then another aspect that will also be on the agenda is, for instance, about the economic dimension of intangible cultural heritage, and again, ethical issues around it, misappropriation including, that I was mentioning earlier, which leads back to kind of slight side of reflection about, again, these intellectual property or indigenous peoples issues as well. So we see much more kind of awareness about these silenced aspects previously. Much more is now brought up, including issues of inclusivity, and which comes very much in connection with the discussion about sustainable development aspect. So having said all of this, I think there's a lot still to be done around the 2003 convention on these non-consensual aspects, but then also eventually completely novel aspects that will be raised. And yet again, I think it's good to remind to ourselves time after time that there might be these different temporalities existing, and that the way how time can be perceived regarding intangible cultural heritage can be in different manners and should be respected as such. Thank you for your attention.